professionals in their communities. Thank you very much for providing those poll responses. We'll now move on to our third panelist, Steve Tomkowiak, who will discuss the main laws, court decisions, and applicable elements of proof for cases involving unlawful steering. Steve.
Thank you, Kishana, Keith, and Brian for clearly laying out the problem of discrimination in the home buying process. I'm going to address two main points. First, what is the extent of the problem of discrimination or racism in the home buying process? And second, how to prove a violation. I've got 34 slides to cover in about 15 minutes, so I'll go through very rapidly. And again, as been previously mentioned, all the slides will be available. They're available now to be downloaded so they can be reviewed in detail later. To set the context, let's see if it was. It's moving slow. There are a variety of unlawful steering practices. By unlawful, I'm referring to steering practices based on a protected class of a home purchaser, rental applicant, and others. Here, we're going to be addressing unlawful steering that occurs, unfortunately, in the home buying process. We all regard home ownership as the American dream, and it is unfortunate that to have that dream unfulfilled or impaired due to discrimination. So what is the extent of the problem? To find out, HUD funded 3 comprehensive nationwide audits based on steering, using match pair steering, much as what we've seen similar in the Long Island investigation. And these audits, the 1991 report made 2 major findings. First, Black and Hispanic homebuyers were often steered to neighborhoods that are lower percentage white and less affluent than those recommended to comparable white homebuyers or white testers. This we would all agree is unlawful steering. The second thing is that homebuyers who began by asking about the availability of units advertised in major newspapers were likely shown and recommended houses in predominantly white neighborhoods rather than in integrated or majority minority neighborhoods. Now, this is something that's not easily detected as unlawful steering because white, Black, Hispanic testers who were shown the same listings, but the effect on majority minority communities can be devastating and really smacks of a type of redlining. And to me, this is a large problem we face today, whether we're talking about real estate agents or appraisers or lenders. They far too often are located in non-minority affluent communities and disproportionately serve those communities. That's something that's not readily detected as discrimination, but the effect is still the same. The study here, 1991, points out that steering is difficult for individual home seekers to detect. Mapping, as we're going to see in a couple of minutes, looking at Long Island investigation, is a key tool that can be used to establish and show racial steering. The 2000 study showed that white home buyers were favored over Black 17% of the tests, and whites were preferred over Hispanic home buyers or testers in 19.7% of the tests. The study found that geographic steering on the basis of neighborhood racial composition increased significantly between 1989 and 2000. So Long Island is not a one-off, unfortunately. And here's another report on racial steering by agents. And it says here, steering most commonly occurred through informal, unsolicited comments directed to white home seekers about the racial composition of selected neighborhoods. These kind of statements here, and this is a study that's a few years old, dating back to 2003. It's very similar to what we see in Long Island. Still continuing. The next 2 slides kind of summarize what took place in Long Island. It shows quite a comprehensive, hats off to Newsday. He said they're just reporters. Well, they're more than just reporters. They did a great deal of work. And the sad part is the discrimination, the findings that they had is that their discrimination, 19% against Asians, 39% of the time against Hispanics, and 49% of the time against Black testers. It's terrible. The key tool in this investigation is mapping. And here's slide 48. This is what should occur. In the video, there's a video, this picture is taken from a video. The agent here said he made a point of providing the same listings to all home seekers, regardless of their race and ethnicity. That's just the right thing to do. And if you look at it, the blue dots are where the listings that were provided to the white testers, and the kind of orange, reddish dot is where the listings were provided to black testers. You can see they're evenly distributed. The next slide shows of what racial steering looks like when it's mapped. The white and black testers, they're matched up with similar qualifications, were given listings by the agent in different communities. So to answer the first question, yes, discrimination by real estate agents, unfortunately, still takes place in the home buying process, and this occurs too frequently. As Brian pointed out, agents know better than this. Professor Schwem said it's not too much of a burden for agents to do the right thing in order to provide the same listings to everybody, regardless of their race or ethnicity. So the second and very important question is, what are the standards for proving a violation? What can we do when this occurs, when there's steering in our communities? First off, it's kind of maybe surprising that steering is not mentioned in the Fair Housing Act, the Civil Rights Act of 1866 and 70, or an Equal Credit Opportunity Act. There were two earlier Supreme Court decisions, Gladstone Realtors in 1979 and the Supreme Court's Havens Realty Corp decision. You can see there's realtor names right in the names of the parties in the cases. In those cases, the Supreme Court was addressing standing, who could bring a claim, but they did, again, almost implicitly recognize that steering was a violation of the Fair Housing Act. Following those decisions, of course, all lower federal courts found that steering would violate Section 804A of the Fair Housing Act, discrimination in denial, refusal, or otherwise make unavailable housing, discrimination in 804B, terms and conditions, C, discrimination as to discriminatory statements, and D, misrepresentations regarding availability of housing. HUD addressed steering in 100.70 of its regulations implementing the Fair Housing Act, defining it as a violation of 804A. That's real helpful. We're going to go in a little bit more detail in a second. And here's kind of the best definitions for steering are the Supreme Court's decisions in Gladstone Realtors and Havens, directing prospective home buyers interested in equivalent properties as to different areas according to their race. Havens has a very good definition as well. A real great definition, though, is explained by eventual Circuit Judge Damon Keith in a case that's still frequently cited, even though it's an older case, it's still cited often today, in Such versus Hussey. And basically he says that steering deprives, the key flaw or violation in steering is that deprives the home seeker of the freedom of choice. And this kind of steering can be done by word, phrase, or action. And to put it in Judge Keith's words, where choice influencing factors such as race are not eliminated, freedom of choice in the purchase of real estate becomes a fantasy. It is the freedom of choice for the purchaser which the Fair Housing Act protects. It's a great statement on what steering is. Judge Keith's freedom of choice policy is carried over into HUD's regulation. Section 100.70A, subsection A, prohibits, based on protected class, the restriction or attempt to restrict the choices by word or conduct to perpetuate segregated housing patterns or to discourage or obstruct choices. Should be noted here, you do not have to establish that steering segregates or perpetuates segregated housing. It's great if you can, but the real proof standard simply requires that housing choices have been discouraged or obstructed. And the second part, 100.70 subsection B, talks about the provision of housing or services. Now, there also, HUD regulation will give example of what the violations are. There's 4 examples in 100.70C. First one is discouraging inspection or purchase because of the protected class of persons in a community or development. The second one is exaggerating drawbacks or failing to inform of desirable features of housing in a community or development because of protected class status. Or another one would be telling a prospective purchaser that he or she would not feel comfortable or compatible with existing residents. The fourth example is assigning a person to a particular section of a community or development. There's 5 additional examples in subsection 100.70 subsection D, and the examples include under 2, using codes or other devices to segregate or reject applicants. And here's a big one when we talk about real estate agent steering: refusing to take or show listings, or refusing to deal with certain brokers or agents. So the question is, who can bring a claim for unlawful steering? Pretty much anyone. Over here is home seekers. Certainly they have claims. Residents in the community affected by unlawful steering, municipalities, fair housing organizations, testers, even a seller, denied the opportunity to get a full market value because the homes are not being showed or listed. His or her home listing is not shown, would have a claim as well because they've also been aggrieved or injured by an unlawful steering practice. So who would be responsible parties? HUD has a regulation 100.7 and the Myers Supreme Court decision deals with that. Anyone who's involved in unlawful steering and owners and brokers whose agents engage in unlawful steering can be liable as well. I know Keith mentioned about how kind of common defenses keep getting raised. One that came up in some of the cases, they're arguing, well, broker would argue, well, the agent is simply an independent contractor, not responsible for what that agent did. Doesn't work that way. Independent contractor status does not preclude liability against a broker. Liability under fair housing cases is based on federal law, not state law. Independent contractor is a state law definition. It doesn't have any bearing when it comes to liability under the Fair Housing Act. We still have direct liability, and responding at superior applies as well. So here's the question. So how do you prove it? Unlawful steering requires proof of intent. There may be, I'm just not aware of any cases that have had steering cases where it's been based on a disparate impact theory of liability. There may be, I just didn't see any. However, when it comes to intent, the intent may be established through direct or indirect circumstantial evidence. There's no need to show that steering was successful. Attempt to do so is itself unlawful. And another factor too is that a single incident of unlawful steering is sufficient. Yes, establishing a pattern and practice is a requirement only for a Department of Justice claim. It's not the standard for a private cause of action. If it can be shown that it's a pattern and practice, great. It's just that this is just not a requirement for liability under the Fair Housing Act. And this one, these are examples showing direct evidence of discrimination. I'm not going to read these, but the one on the right in East Hampton, the Hispanic community came in and they really took over Springs. That's direct evidence. That's direct evidence. Probably other two in the context of the whole test as being recorded were probably, I'm sure, would show direct evidence of unlawful steering. In the absence, in probably most of the cases, there's no direct evidence of unlawful steering. The challenge is to come up with the effective elements of a prima facie case of discrimination. The court on the top in Metro Open Communities versus Rossi Realty noted that the typical prima facie case in fair housing claims do not readily apply to steering cases. So various formulations have been adopted by HUD in its elements of proof memorandum and by the courts. The Cabrera case at the bottom simplifies it, and it says as long as the plaintiff can prove that a defendant afforded an African-American person fewer housing opportunities than a similarly situated white person on account of race, the plaintiff has made out a prima facie case under Title VIII. That's a pretty good threshold. I'm just going to run through real quick. HUD has different elements of proof. The first one gives 5 prima facie elements for indirect circumstantial evidence of unlawful steering. This one involves that there's a segregated neighborhood. A second standard that HUD puts is when the steering involves someone being steered to less desirable housing. And these are 4 elements of a prima facie case for that type of a claim. In looking at some of the cases, HUD versus Housing Authority of Las Vegas lists 4 prima facie elements in a case similar to HUD's elements of steering in a segregated neighborhood. And the one I really think is a recommended one, the Village of Bellwood case. Again, the previously mentioned ones do not really fit exactly into a real estate steering context. So I think Village of Bellwood may be the best one. And here's it's a very low threshold. So blacks were shown primarily houses in black areas and whites primarily houses in white areas. I'm sorry, where the evidence shows blacks were shown primarily houses in black areas and whites primarily houses in white areas to place on the defendants the burden of giving a non-invidious reason for the differences in treatment. Non-invidious means a non-discriminatory reason for the difference in treatment. All that has to be shown, blacks were given homes in black areas, right? And whites were given homes primarily in white areas or majority white areas. That's sufficient. And then it shifts the burden of production of a non-discriminatory reason onto the defendant or the real estate agent. That's a very common sense approach, and I think it would work. Federal Circuit opinions, that's one step below the Supreme Court. They're considered very, very persuasive in how the law should be applied. The Village of Bellwood case also proposed, as when it sent the case back down to the trial court, the district court gave a sample helpful jury instruction to use in steering cases. It is very, very helpful. And even if you decide there's no or insufficient direct evidence, if you find the defendant showed black customers, primarily homes in predominantly black areas, and their white customers, primarily homes in predominantly white areas, and if, in addition, you do not believe the defendant's explanation of this pattern, Keith didn't seem to believe the explanation of the agents he spoke to, I didn't either, then you may infer that the defendants were steering their customers racially in violation of the statute. It's a great standard. So what are likely defenses? This shows mapping, right? Under this standard, this would be a violation. So what do they raise? Well, it's like what Keith put it, honest information about the quality of performance of school districts, right? The customer has asked for, we gave honest information. Is that a good defense? Professor Schwem, in his wonderful treatise, differentiates three types: salesperson initiated discussions, which is what you have in Long Island, customer initiated discussions, and customer initiated questions. And again, those are, different kind of frameworks that occur, right? And I think Brian gave examples of how things should be answered, right? You can have the customer or the home seeker find that information out. But if it's whatever information is given by the real estate agent, if it's done in such a way that will unlawfully influence the home seeker's choice, that's a violation. Judge Keith and Zuck addressed this as well. Whether it's done on the agent's own initiative or response to the buyer's initiative, the agent either directly or indirectly discourages the prospective home buyer from purchasing a home in a particular area, right? That's what constitutes unlawful steering. Just real quick, another one that can be raised, well, being helpful with the information, right? Or giving them accurate information to make sure that they don't go into a, quote, dangerous neighborhood or something like that. Helpful or paternalistic steering or defense doesn't fly in fair housing. It's still discrimination. Regardless of the motivation, I think it's suspect even to call it helpful or paternalistic. Another factor could be economic motivation as well. And there's case law which would reject that as well. Why is someone, putting a white home seeker into a white area? Maybe they're high value properties. Well, I suppose, but if that's the motivation or the factor, then the white or the black home seeker, Hispanic home seeker should have been offered those same housing opportunities in affluent neighborhoods as well. But just I have a couple illustrative cases that look at common defenses. I'm not going to go through those, but the takeaway is this: the Supreme Court decisions in Havens and Gladstone Realtors and Judge Keith and Zuck arm us with effective definition on unlawful steering against home seekers. Second, one or more of the subsections in HUD's regulations, section 100.70, pertain to steering should apply to your case. Next is that the legal standard of proof in racial steering cases involving words, actions, or conduct of real estate agents is readily met. Particularly the Cabrera and Village of Bellwood cases show that standard. These standards are not too difficult, regardless of whether the case involves direct or indirect circumstantial evidence. Finally, there's helpful case law when it comes to address these common defenses. So the bottom line is that I hope this presentation helps arm you with the tools to understand and effectively address incidents of unlawful steering by real estate agents. Thank you.